If you have a dispute with your landlord, you're generally advised to make a claim to the Office of Residential Tenancies, and then you should get a hearing within a month. Since legalization of recreational pot, many Saskatchewan landlords are prohibiting their tenants from using or growing cannabis on the premises. That's even medicinal users. And one cannabis lawyer says they should expect legal challenges.
If you are intending to grow in your dwelling, does not require you to get the permission of the property owner. And that's intentional by the federal government. It's for a reason. It's because the courts of this country have told the federal government time and time again that, they have a duty under the charter to provide reasonable access to cannabis for medical purposes to people. And the courts have now been specific that reasonable access has to include the right to grow your own cannabis.
The Office of Residential Tenancies in this province hasn't received any complaints about these policies yet, but it could, and very soon. Shane Moore says he's already filed a complaint with the Human Rights Commission, and he plans to contest any eviction notice he might receive. A manager from the ORT told me people in this situation can appeal the new policies specifically. If a rule has changed during their lease, they can get a hearing to determine if the new rules are reasonable. Now, reasonable is a tricky word here. As we heard from Trina Fraser, medical cannabis patients are ensured reasonable access to their medicine. But landlords in this province are allowed to enact reasonable rules prohibiting marijuana use and growth. So who's in the right here? Well, we'll have to wait to see if the ORT receives any complaints and then see which way the hearing decides. Bridget Yard, CBC News, Saskatoon.